Hi everyone, welcome to the Black Letter Law Academy. Today we are going to discuss part 1 of the Indian Constitution, Article 1 to 4. We will break every step by step in very simple way. If you find law difficult, stay till the end and subscribe for more simple explanation. By the end of today's class, you will confidently say, yes, I clearly understand Article 1 to 4. Alright. Now let us understand Article 1 of the Indian Constitution. First, the name of our country. Article 1 clearly says India, that is Bharat. Simple question for you. Does our constitution recognize one name or two names? Yes, both India and Bharat are constitutionally valid. Now comes the most important part, the nature of India. Article 1 says India is a union of state, not a federation formed by agreement. Can any state say I want to leave India? No. Why? Because India is an indestructible union. States do not have the right to secede. This is why Dr. B.R. Ambedkar beautifully described India as an indestructible union of destructible states. What does this mean? India's unity cannot be broken, but its states are flexible. They can be created, altered or reorganized. Now let us understand the territory of India. Okay, according to Article 1, the territory of India includes three things: states, union territory, then territories that may be acquired in future. Okay, the names of the state and union territories are listed. It is in first schedule of the constitution. Now let's connect with the real example so you never forget this concept. Okay, so Goa was acquired in 1961, which is example of future acquisition. Sikkim was added in 1975, a new state joined the union. Telangana was created in 2014, a new state formed. Then the Jammu and Kashmir were reorganized in 2019, state structure changed. Okay, this example for us to understand how the state and union territory of India evolved after independence. When the Indian constitution came into force in 1950, India did have the simple system of states and union territories that we see today. Instead, the constitution followed a classification that was largely influenced by the colonial administrative system. At the time, the country was divided into 4 categories. Okay, so part A were the former British governor province, and part B states where the princely state ruled earlier by Indian ruler. Part C states where chief commissioner province administered directly by the state. Part D, Andaman and Nicobar Island. This system created serious problems. It continued administrative functions and treated states unequal. More importantly, it completely ignored the linguistic and cultural aspiration of the people, when though language played a major role in daily administration. Because of this problem, the government felt the need to examine whether the states should be reorganized. As a result of several commissions and committees were appointed. The first was the Dar Commission in 1948, headed by Justice S.K. Dar. This commission suggested that states should be reorganized only on the basis of administrative convenience and strongly rejected the idea of linguistic states. Okay, so the reason was that language-based reorganization might weaken the administration and unity. So soon after this, the JVP committee was formed in the same year. This committee included Jawaharlal Nehru, Vallabhbhai Patel, Pabi Sitaramaiah. The JVK committee also rejected the formation of linguistic state and emphasized that national unity was more important than the linguistic demand. Okay. However, public dissatisfaction continued to grow and linguistic movements became stronger across the countries. Because of this increasing pressure, the government appointed the Fazl Ali Commission in 1953. Fazl Ali Commission accepted language as the primary basis for reorganization, but clearly stated that language alone was not important, was not enough. It also considered the administrative efficiency, economic viability and cultural factors. The commission recommended the creation of 16 states and 3 union territories. These recommendations led to the major constitutional change in 1956 through the State Reorganization Act 1956 and the 7th Constitutional Amendment Act 1956 passed. After the State Reorganization Act 1956, India was reorganized into 14 states and 6 union territories, a significant reconstructing along linguistic line that also abolished the old Part A, Part B, Part D state categories, establishing a new framework of state and union territories. Okay, this organization was done to ensure the equality among states, administrative simplicity, linguistic satisfaction, and then most importantly, national unity. The purpose was not to divide the country but to manage the diversity in the way that strengthened the union. Okay, now let us understand the difference between the states and union territories. India has 28 states. Each state has its own elected government, its own legislative and chief minister. Let me ask you a question. Who run the state? The central or state itself? The answer is the state government. Okay. Now coming to the union territory, India has 8 union. These are administered by the president through an administrator or lieutenant governor, which means they are controlled by the center. Okay. So, do union territory have the same power as the state? No. Some union territories have a partial legislature. They can make law on certain subjects. The parliament has overriding authority. For example, Delhi and Puducherry have a legislature, but they are not equal to states. So remember quickly, states are self-governing and union territories are centrally governed. Now let us understand Article 2 of the Indian Constitution. Article 2 gives the power only to Parliament to admit or establish a new state. State themselves cannot take this decision. So Parliament only have the power. Article 2 uses of 2 important terms. One is admission, another one is establishment. First see admission. What is admission? Admission means adding a territory that was not a part of India earlier. For example, Sikkim in 1975 was admitted as a new state. Okay, that is admission. And the second term is establishment. Establishment means creating a new state within India's existing territory. This is existing territory. Previous one was not a part of Indian territory. So for establishment, example is Telangana in 2014 was established by bifurcating Andhra Pradesh. Okay, then Article 2 also allows Parliament to fix terms and conditions. This includes new states' boundaries, functioning and its relationship with the Union. So remember this point, only the Parliament has the authority to admit and establish new states in India. Now let us move to Article 3 of the Indian Constitution, which is very important and very practical provision. Article 3 deals with the formation of new states and alteration of existing states. This article clearly shows how flexible the Indian federal system is. So Article 3 says that Parliament may by law make change relating to states. So first remember this clearly, the power lies with Parliament. Now let us understand what exactly the Parliament can do under Article 3. First, the Parliament can form a new state. This can be done in different way. A new state can be formed by separating territory from an existing state. A good example is Telangana in 2014, which was formed by separating territory from Andhra Pradesh. The second one is Parliament can also form a new state by uniting two or more state or part of states. It can even unite any territory with a part of state. And the third one is by uniting any territory with a part of state. Okay. So the next one is Article 3 allows a parliament to increase the area of states. This means adding the territory to an existing state. Parliament can also diminish the area of states, which means taking away the territory from a state. Further, Parliament has the power to alter the boundaries of the state. This includes changing the border between states. Parliament can also alter the name of a state. For example, Madras was renamed Tamil Nadu in 1969. Orissa was renamed Odisha in 2011. Now comes a very important procedural safeguards. A bill under Article 3 cannot be introduced in Parliament freely. First, the recommendation of the President is compulsory. Second, if the bill affects the area, boundary or name of a state, the Parliament must first send the bill to the legislature of that state. The state legislature is given time to express its view, but remember this clearly. Parliament is not bound by the option of the state legislature. The state legislature gives its view within the time specified, but Parliament is not bound to accept those views. Okay, then Parliament may accept it, modify it, or completely ignore it. So, this is an example which already discussed. Understand the constitutional philosophy behind Article 3. India follows a flexible federalism. This means the union is indestructible, but states are reorganized. To understand the limitation of Article 3, we must look at the important case, Re-Berubari Union case. The issue before the Supreme Court was this: can Parliament use Article 3 to transfer the Indian territory to the foreign territory, namely Pakistan? The Supreme Court clearly held that Article 3 allows Parliament to diminish the area of state, but does not include the power to cede Indian territory to a foreign country. The cession of the Indian territory to another country is not covered under Article 3. Such transfer can be done only through the constitutional amendment under Article 368. So remember, Article 3 only allows internal reorganization of the state but not transfer an Indian territory to the foreign nation. Okay. Then now let us understand Article 4 of the Indian Constitution. Article 4 explains what happens after a law is made under Article 2 or Article 3. It says that any law made under Article 2 or 3 must also update the Constitution in certain place. First, it must update the first schedule, which contains the list of states and union territories. Second, it must update the fourth schedule, which deals with Rajya Sabha representation. Such a law may also include extra detail or incidental detail like representation in Parliament or state legislative. Now comes the most important point. Even though these laws change the schedules, they are not treated as a constitutional amendments. They are passed as an ordinary law by a simple majority in Parliament. So remember this clearly. Law under Article 2, 3, 4 or ordinary law, not amendment under Article 368. This is your sum up. We started with Article 1, then 2, 3, 4. Just quickly recall these concepts. For more lecture videos, subscribe to the Black Letter Law Academy and share to your friends. We will continue with more important constitutional topic in the next class. See you soon. Keep learning. Happy learning. Bye.